Hello, and welcome to Hospice Insights, the Law and Beyond, where we connect you to what matters in the ever-changing world of hospice and palliative care. Get up to speed fast. What you need to know about the new rules involving non-competes and exempt employees. Tom, it's been a while, but this is like third, fourth time on the podcast.
It is. I'm honored. Absolutely enjoy it.
Well, I feel like the labor and employment area is like just busy these days, like with things that are making like headlines in like the New York Times and
right.
Other things. So let's start with the juicy one, which is about this rule that was released about non-competes, or essentially you can't have non-competes. Can you break that down about the who, what, why, where?
Yeah, so traditionally non-compete agreements are thought of in a very general term, and it's important to remember there are different kinds of restrictive covenants, we call them, or non-compete restrictions. Some of them are more invasive of employees and their ability to move from one employer to another. Some of them are not so invasive and are, in balance, very protective for employer interests. So I always start with just kind of a background of the types of restrictive covenants. The first one is a protection for trade secrets. And that may not be applicable so much to hospices, but that's one type of protection that all companies have. In addition to the patient health information and HIPAA obligations and other confidentiality requirements specific to healthcare, you can have a confidential information restriction that applies to all of your employees as well. And that it can be done by contract, oftentimes is done by contract. It might be in an employee handbook, but probably better to do in a separate standalone document.
Tom, what does that mean? Like you can't like non-solicitation thing, you can't contact my other employees if you leave, or what does that mean, what you just said?
So this confidentiality agreement would be things like you can't share information about our hospices. I suppose it could be patient list or client list, but it wouldn't be patient health information. But I guess names might be all that would be required. But it would be things like protecting confidential information about the business strategy. So if the business intends to expand into another geographic area, or if they intend to work with another partner in providing hospice services, that might be non-trade secret confidential information that a company may want to protect with its employees. So another kind of restriction is that employee non-solicitation restriction. The idea that you can restrict an employee from soliciting their former colleagues after they leave employment to go work with them somewhere else in competition with your organization and your service. So that's an employee non-solicitation restriction. There's a patient or a vendor or a supplier non-solicitation restriction that you can have in place. And that would say that after the end of employment, the employee cannot solicit patients or families or partner service providers to leave your hospice service and go to another hospice service. And the final type of restrictive covenant and the type of non-compete restriction is a geographic non-compete restriction, something to the effect of you can't work for another hospice within 10 miles of the facility located at some address. So all of those different protections are important to keep in mind for your employees, and you want to take advantage of those protections where it makes sense. And again, I think you should have a confidentiality restriction with all of your employees. I think you should have an employee non-solicitation restriction with all your employees, because it's important, and you spend time and energy in training employees to bring them up to speed on your service that you're providing. And it's important for you to protect that investment that you're making in new employees by making sure that you can't have former employees just picking them off and rating them whenever they can. And then I think for client facing, for employees of the hospice, like marketers, that are working with partners of yours, you may want to have a vendor, supplier, patient restriction that applies to those marketers or some other level of employee like an executive as well. And that's reasonable. That's fair. That's in balance in exchange for the employment that you're offering to someone, having them return the favor with a promise not to solicit people to compete against you is, I think, fair in a lot of circumstances.
So what did the administration do with this new rule? Because the headline's like, you can't have non-competes anymore. So what are they saying?
So the new Federal Trade Commission rule that has been finalized, and we've known it was coming for some time. It finally came and is now planning to take effect. That rule only prohibits geographic non-compete restrictions. So it only prohibits those types of agreements that say you can't work for any hospice service within a 10-mile radius of our facility, or a 10-mile radius of this location, whatever it is, or in the state or county in which the hospice service is located. And the FTC did not prohibit the use of confidential information, employee non-solicitation restrictions, or patient, vendor, supplier, partner non-solicitation restrictions. And that's an important distinction because those other types of protections, the confidentiality agreements, the employee non-solicitations, the patient, vendor, supplier, partner restrictions, those are all something that we can continue to use in the industry, and we should continue to use in the industry where they're fair with the employee and the employee is getting something in exchange. One important thing to keep in mind about this proposed rule from the Federal Trade Commission is that it does not apply to nonprofit organizations. So for healthcare, that matters. Obviously, for the hospice industry, that matters. If you're a nonprofit organization, then you don't need to worry about application of this rule because the Federal Trade Commission does not have authority over nonprofit organizations. The FTC did say, however, that they are going to be watchful for the need for organizations to be truly nonprofit. So they used an example of a physician group of individual physicians who forms a corporate entity that might be listed as non-stock or nonprofit, but really which is used to share compensation at the end of the process with those individual physicians. And the FTC pointed that out as an example of something that, although it might be labeled as nonprofit, that might still be subject to the rule. So if you're a private industry, private owned organization, then the FTC would apply. But if you're a nonprofit organization, the FTC rule would not apply to you.
So probably, again, people want to sell newspapers or get clicks. So I think the headline, it's maybe overstated, at least a little bit in terms of scope, because as you just laid out, there's lots of different things that you can continue to do. But the geographic thing too, even before this rule, I mean, at a state law level, like a lot of states had their own limitations on non-competes and stuff. So that geographic thing, I felt like was always somewhat in flux, depending on where you are or whatever. Given that you might not have employment agreements with a lot of the employees of your organization, you talked about using a handbook for that. Your CNA, your nurses, your other people, as opposed to your executive director is probably going to have, an employment agreement. Where do you put this stuff, Tom?
It can be done in separate standalone agreements. They don't need to be over legalese. They can be in plain language, and they don't need to be intimidating for employees. And I think with a new employee during the orientation process, of course, they're signing things like independent policies that you might have in place. They might be signing an acknowledgement form that says they received the employee handbook that the organization has in place. They're, of course, going through benefits paperwork and other kinds of new hire paperwork. A 1 or 2 page confidentiality restriction or employee non-solicitation restriction or patient, vendor, supplier, partner non-solicitation restriction can be part of that process when you're onboarding every new employee in the organization.
Got it. So the fact you don't have an employment agreement, there's another way you can do that, but you make it part of your process. Is there any benefit to, I'm just thinking, if you refer to the employee handbook, it seems like it would be easier if that's updated to then be like, well, you accepted the new terms or something. Is there like a benefit? I don't know how much stuff this changes, how often that you would really want to update it, but is there some benefit that then you can integrate any updates through the employee handbook? Or
generally, you never want an employee handbook to be considered a contract. And most employee handbooks at the front of them will say, this is expressly not a contract. It's not a promise or an employment agreement for future employment. You're an at-will employee, generally, is language that's included in all those employee handbooks. And you don't want it to have contractually binding restrictions. So for that reason, it is better to use separate standalone agreements for the confidentiality of the employee restriction and then the vendor, patient, partner non-solicitation restrictions.
Got it. So, well, and I'm sure you do those all the time, Tom. So for people listening who don't have those, it sounds pretty important to have them because, we've been involved in situations where, of course, the bad story happens. And then, it's not like you can't try to dispute things, but better to have something well drafted on the front end that they signed than us as lawyers trying to piece together other things.
Right. Yeah, I'm proud of the template or the form that I usually start with for these types of restrictions. And again, I do think it's in plain language. It's fair to the employees. It's not overbearing in both kind of substance nor necessarily form, just looking at it. I don't think it should scare employees off. You mentioned earlier, Meg, the need to keep state law in mind. And historically, non-compete agreements and contracts have always been the purview of state legislatures and state courts. This intervention by the FTC in the federal level is new. It started happening in the current administration with the National Labor Relations Board has entered the fray and said that non-compete agreements might be violative of federal labor law. President Biden issued an executive order early in his administration asking for input on non-compete agreements and wanted to generally take more of a regulatory role from the federal government side. But state law still does matter, and state law changes. So to the extent that there are organizations that have had a non-compete restriction at any level, confidential information, employee restriction, or geographic restriction, it's important to keep those updated and make sure that they still comply with the most recent state law and any changes that have occurred in that particular state.
And that's what's great about being at Husch is, and you and I came to Husch at the same time, but we have labor and employment colleagues in so many different states that are staying on top of all of this that we can always tap when needed when we're helping our hospice clients, since we have hospice clients, I think, in every state now. So all over the place. But the last thing I wanted to touch on, even though it's, I think, been somewhat less in the headlines, maybe before we leave the non-compete, is just this is getting contested in court. So, this whole non-compete, which is, again, limited to geographic limitations, is being challenged in court. And I think when you and I were prepping, you were saying a decision coming down from one judge. Was it July 3rd or something?
Right. The intervention of the federal government in this way, and the Federal Trade Commission specifically, is probably unprecedented. And a lot of observers do see it as overstepping the bounds of their legislative authority. So there are court cases pending. They're pending in district courts in the state of Texas, which is typically the jurisdiction or the haven for people challenging federal rules that they don't like.
No, really? I didn't know that.
It's a great place or an awful place, depending on what you think. But the court in this district court that has these cases in front of it has said that it will make a decision before or on or around July 3rd. And that's helpful because the rule is currently in effect. The rule is set to take place on September 4th. But if the court enjoins it on July 3rd or so, that happens, and then the rule doesn't go into effect until it is dealt with in the court system. But if the court does allow the rule to continue to move forward, there's still a fair amount of time between that July 3rd timeframe and September 4th for employers to deal with it and really manage whether or not you have to adjust compensation or adjust terms and conditions of employment or whatever it might be as a result of the rule potentially going into effect in early September. So there'll be enough time. And what I'm advising clients to do is stand by on the rule until early July, and by then we'll have a good decision, a good direction of whether or not we need to take steps to prepare for it or not.
And so if the Texas court says no, this rule isn't legal or it's enjoined, so there's an injunction, then that would apply to essentially the entire United States, similar to during COVID, there were likewise different injunctions that happened that stalled like federal rules on things. So whatever the Texas judge decides will have impact to other states, is what you're saying?
Correct. Most likely, almost certainly.
Yeah. Well, never a dull moment in your world. So I know this was last headline worthy, but since we're doing sort of labor and employment update, this whole thing about who can be considered exempt employees versus non-exempt employees, this has been covered, highlighted by, the Home Care Association. And, I also think it could impact hospices. So what is this whole new rule about? Because it essentially says you got to pay people overtime that you might have not had to before. You said that they were exempt.
Right. So generally, there are two things that need to happen in order for an employee to be properly exempt from being paid overtime. One is that they have to perform specific duties in their job. And that can take a wide variety of different things. But for the most part, it's you either supervise 2 or more full-time equivalent people, and then you can satisfy that duties test, or you exercise discretion and independent judgment in your job such that you're exempt from overtime requirements. Those are generally...
So it's one or the...
It's or, correct.
Okay, so it's not
right.
Both. Okay.
Yep. Then in addition to that duties test, the second thing that you need to meet in order to consider an employee exempt is a salary threshold. For many years, if you have made more than $35,000, $35,568 to be exact, then you could be considered exempt from overtime if you met those duties tests as well. What the new rule from the Department of Labor says is that as of July 1st, 2024, that salary threshold will increase from $35,568 to $43,888. And then on January 1st, 2025, that salary threshold will again increase to $58,656 per year. What that means is, and there's more to the rule, but that's the biggest relatively short-term impact of it. So if you have employees that you have considered exempt traditionally in your organization who are making between $35,568 and $43,888, you now need to consider how to address them in the next 6 months or so. Well, I'm sorry, for that you have to decide how you're going to address them before July 1st. And then at some point, you'll have to address whether or not you increase their salaries above $58,656. So really, I think the first step for employers is to figure out how many employees that they consider exempt at this time are making less than those new salary thresholds as of July 1st and January 1st.
Yeah. So, and again, when we were prepping, you were saying the administration says this could impact, what was it? You said 4 or 5 million individuals they anticipate would essentially now get overtime that they were essentially not getting paid for.
Correct. That would be the economic impact of the rule change.
Yeah.
And employers have the choice. They can decide we're not going to increase salaries and we will pay overtime going forward. Of course, that means their practices would need to change. You would need to track overtime. One thing that an often kind of misnomer, a belief that's not accurate, is that you have to then change someone from a salary to hourly pay. And that's not the case. You can still have salaried employees who are getting overtime compensation. The calculation needs to be, made, but that oftentimes is something that's missed by human resources. And it's important because I've been shocked over the years. This issue of exemptions from overtime has come up at the federal level, and when you do need to make changes with employees, a lot of employees see it as a demotion just to be called an hourly employee.
Oh.
So for employment relations purposes, it has nothing to do with the law, but keeping someone at a salary, but still considering them to be eligible for overtime is probably a better human resources action than saying, sorry, we're not going to move you up to $43,000 per year, but now we're also going to make you an hourly employee, and congratulations, you now make $30 per hour instead of, $40,000 a year.
Yeah. See, this is why I call you Tom.
The practical
I'm a licensed
impact.
Yeah, well, it's always so funny. People think oh, you're a lawyer, and then they get into some trusted estate stuff and my eyes glaze over or all this other stuff. That was, getting on 30 years ago, I started law schools. Right? Yeah, I don't remember any of this. This is why I work at a firm with people who are very skilled in these things like you, that because as you're explaining that, I sort of think the same thing. About if you're hourly, that's who gets overtime, and salary people don't get it, So
right.
So I guess I'm not the only person in the world that thinks incorrectly about that.
Right. The other thing to keep in mind, similar to the FTC non-compete rule, is there are still state laws that govern when you have to pay someone overtime compensation. So the state laws will still be in play, and some of them are more generous to employees for how much overtime compensation has to be paid to them, and others are either the same as federal law or maybe even worse, but the employee gets the better of the two. So federal law demands that they're paid overtime. You've got to pay that, even if the state does not.
Well, and I guess just a final comment, as you were talking about federal and state, I remember talking to some clients who service Chicago area, but they're, not in Chicago land necessarily, their headquarters, but they go into Chicago proper, and how the city has different minimum wages than the county versus the state versus, and it was oh my gosh, how do you keep track of this? And then it's does it matter? So if this one employee goes to Chicago for one visit, but then they're going somewhere to some other city, how do you keep track? I was just, all these things I don't think about, Tom.
Yep.
It's that's complicated.
It is. But always changing as well, which is nice. And it's not just the agencies taking steps to change the law, but it's also the courts stepping in as well. And again, similar to the FTC rule, this Department of Labor overtime exempt rule has been challenged in courts, similarly in the state of Texas. And it's the same. I know it's shocking. It's the same area and courts that have invalidated these kinds of overtime exemption rules in the past. It happened in 2016. It's being challenged from a Trump administration rule in 2019. So it's common. It's going to happen. And in this case as well, we should know in the next couple weeks whether or not a court is going to stop this from taking effect before July 1st as well. So a lot of court activity will be coming ahead of the holiday, and it could be significant.
So you're just me hunkered down over the 4th of July, just like eagerly awaiting. Who needs a vacation when I can read court cases?
Or I can anticipate what's going to happen and have those alerts drafted already. Because I do think, I do believe that both the FTC rule and the wage overtime exemption rule will be put on hold by courts. I don't think either one of those will survive our July 4th holiday.
So I just want to, knowing nothing about this other than what you taught me today, and I want to be contrarian, I should take the opposite view and bet you what?
There you go.
A cocktail or something?
I just sent an email out to our whole office about the 50 or so bratwursts that I got because I presented at a conference yesterday. I opened this bag and was just shocked at how many brats were in there.
Wow.
So I can't eat all of those.
How can one even
some of my brats?
So probably everyone knows that I'm in Madison, Wisconsin, but Tom actually works in the Madison office with me. So do people eat brats outside of Wisconsin? They do, right? I don't know. Seems Wisconsin-y.
You'd be missing out if you're not.
And I learned from my dad that there's bratwurst patties. I didn't know that. I'm a vegetarian. So I didn't know that we've moved from the sausage form to a patty form of the bratwurst. So any listeners, if you want a free brat, email Tom O'Day, right?
Stop by our office, sure.
Yeah, exactly. It is a beautiful time to be in Wisconsin. Anyway, well, this is wonderful. Thank you for teaching me all this important stuff, Tom, that I don't know. I don't want to know. I just want to be able to call you and tell me, hey, Tom, what should we do here? So Thank you for always being that guy.
Sure. Yeah, it's a great opportunity. The new changes, the attention from the federal government is going to generate a lot of press. And you started off, Mike, by pointing out this is hitting general media, the New York Times, the local newspapers. And it's an opportunity for human resources to review the overall way that they use non-solicitation restrictions and the confidentiality and trade secret restrictions, and also an opportunity to evaluate those individuals that you do consider exempt from overtime, because there's going to be a lot of attention around it in the next couple of weeks, and HR can get ahead of that as well if they can.
All right. So we won't do a podcast with each and every new decision that comes out, but it sounds like there's interesting times ahead. So until next time, Tom, thank you.
Thanks for the invite.
Well, that's it for today's episode of Hospice Insights, The Law and Beyond. Thank you for joining the conversation. To subscribe to our podcast, visit our website at hushblackwell.com or sign up wherever you get your podcasts. Until next time, may the wind be at your back.